Hi everyone, welcome to Legal Connect. Welcome to yet another episode from this space, the space where we look at legal issues concerning our country, Nigeria. Today we are going to be looking at the Money Laundering Prevention and Prohibition Act 2022. As the title sounds, it has to do with prevention of money laundering. Before we go into the discussion today, I want to encourage you to subscribe to this channel if you appreciate the episodes that we've posted so far. And also, I want to encourage you to provide comments, whether general comments or comments specifically to the materials or the contents that we have posted. Um, Today, we are going to be looking at the Money Laundering Prevention and Prohibition Act 2022. And as you will see, this is a new law which came into being on the 12th of May 2022. On that day, President Muhammadu Buhari signed the Money Laundering Prevention and Prohibition Bill at the time, as it then was, into law. And the Act, which is the 2022 Act, repealed and abolished the Money Laundering Prohibition Act 2011 as amended. And you would see that they have taken prohibition and expanded it to prevention and prohibition. That is the first thing that you notice as being the difference between the 2011 and the 2022 Act. Is the 2022 Act, is it a silver bullet? Time shall tell, given the fact that this law came into being in May of this year. However, let's dive into the fundamental objectives of this Act in order to see what the provisions of this law or this Act has. One of the fundamental objectives of the Act includes strengthening the existing system for combating money laundering and related offences, making adequate provisions to prohibit money laundering, expanding the scope of money laundering offences, and also providing appropriate penalties. The law, as we will see, establishes a special control unit against money laundering under the Economic and Financial Crime Commission, which is the EFCC, for effective implementation of the provisions of the Act. If we consider Section 1 of the Act, which is Part 1 deals with objectives of the Act. We're going to look into aspects of Part 1 today. And Part 1 of the Act, Section 1, is the objectives. That's the objectives of the Money Laundering Prevention and Prohibition Act 2022. And Section 1 of the Act states, Section 1, Subsection 1, the objectives of this Act are to provide for an effective and comprehensive legal and institutional framework for the prevention, prohibition, detection, prosecution, and punishment of money laundering and other related offences in Nigeria. Strengthen the existing system for combating money laundering and related offences. Subsection C, 1C, makes adequate provision to prohibit money laundering. Expand the scope of money laundering offences and provide appropriate penalties. And subsection 1E, establish the Special Control Unit against money laundering under the Economic and Financial Crimes Commission for effective implementation of the money laundering provisions of the Act in relation to the designated non-financial businesses and profession. So let's quickly analyze part one of this act and try to understand what the objectives of the act means. Given the position of Nigeria, it is obvious that it is not doing enough, that the government is not doing enough to combat money laundering within the country. Nigeria has signed on to several international treaties and is part of numerous groups tasked with combating money laundering across the globe. Because of the government not doing enough to combat terrorism within the country, Nigeria is actually ranked the sixth most terrorism impact nation globally. And hence, it is essential that we get it right this time with the 2022 Act. One of the objectives of the Money Laundering Prevention and Prohibition Act 2022 was really to build on what the 2011 Act has achieved or failed to achieve, that is to set standard and promote the effective implementation of legal, regulatory, and operational measures for combating money laundering. The law has made much improvement, in my opinion, to the 2011 Act, and we are going to take each sections as we go along on today's episode and subsequent episode, where we'll be looking at the Money Laundering Prevention and Prohibition Act of 2022. Before we look at the next section, I just wanted to say that this is actually the 2022 Act is actually the fourth Act that has been enacted concerning money laundering in Nigeria. The first Money Laundering Act was enacted in 2003, and then there was an amendment in 2004, and then the 2011. First impression will be that, oh, how come Nigeria hasn't been able to get it right? Why is so frequent amendment? The Nigerian society is quite fluid in the sense that a lot of smart ways of doing things in terms of money laundering keep being developed every day. So it is good that the legislators are keeping abreast, following the trend as the society changes, that they are updating and amending the provisions of the money laundering law. And I believe that one day we will get it right. But however, in order for the law to be effective, we need a prudent and effective people to implement it. The people are not made for the law, rather the law are made for people. And so in order for people to abide by the law, we need officers, we need establishments, we need government agencies that are going to be implementing this law to have it at heart to be able to get it right. We expect them to put in more than 100% in getting things right, prosecute those that need to be prosecuted, and free and apologize to those cases that you get wrong. Definitely you will get cases wrong. However, you need to be prudent. You need to be effective in what you do. Don't cut corners, rather implement the law to the latter. That is my quick advice to the government agencies and private establishments that will need to propel the wheels of the money laundering. Section 2, subsection 1 of the Act provides. Section 2 is actually the start of the part 2 of this Act, which is prohibition of money laundering. Subsection 1 of Section 2 says no person or body corporate shall, except in a transaction through a financial institution, make or accept cash payment of a sum exceeding 5 million or its equivalent in the case of an individual, or 10 million or its equivalent in the case of a body corporate. Subsection 2, a person shall not conduct 2 or more transactions separately with 1 or more financial institutions or designated non-financial businesses and professions with intent to avoid the duty to report a transaction which should be reported under this Act, or breach the duty to disclose information under this Act by any other means. So let's look at the provisions of Section 2 as a whole before we move down to the next section. So according to Section 2, individuals or companies are allowed to do cash transaction. What is meant by cash transaction means that when you purchase goods or service, you are allowed to pay by cash. However, as an individual, you are not allowed to exceed 5 million naira cash transaction. So if you're buying something that is, let's say, 5 million 100 naira or 5 million 50 naira, you are not allowed to carry out that transaction by cash. You are only authorized to use financial institutions such as bank to buy the service or product. Let's say, for instance, I'm buying a vehicle and the vehicle costs 5.5 million or 5.2 or 5.1 million. The only way I can pay for that vehicle is to pay the company that is selling the vehicle through the bank, and I'm not allowed to say, okay, let me transfer 2.5 million today, and subsequently I will pay the outstanding amount later on, or paying to this couple of banks. Let's say the company that I'm buying the vehicle from, they have Access Bank and also GT Bank, and I'll split the money into half and pay a percentage into Access Bank and the other percentage into GT Bank. That is under this provision. That is an offense. So it's either I pay the 5 million, which is a limit, or in cash, or I pay the whole amount by bank transfer or by check, alternatively. So I'm not allowed to use my Ghana Must Go to drag 5 million, more than 5 million to the to the car dealer in order to purchase a vehicle. And also under Section 2, a company is not allowed, the limit of their transaction in cash is 10 million. Once it goes past 10 million, they have to also pay for these products or services by financial institutions such as bank. As it applies also to individuals, companies are not allowed to make multiple payments for single transactions. It is an offense to do that. As you can see from the provisions of subsection 2, someone or a company can innocently commit a crime under this provision. Like I said, this law is fairly new, and so it is highly important that the EFCC, that's the Special Control Unit Against Money Laundering, it is essential that there is a public campaign to educate and enlighten the public about the provisions of Section 2. Otherwise, people can innocently be a victim of making a cash transaction over 5 million, because Nigeria, as we all know, is very much cash-based society. We pretty much do everything by cash, and it is going to take time before that mindset is gradually fine-tuned, take people away from relying so much on cash transaction. If you compare the Nigerian society to, say, the Western world, where it is pretty much a cashless society, everything is done through digital banking. Employment salaries are paid digitally. There is no cash per se for payments to employees. There is a traceability that is what the concern is about, being able to trace the history of financial of payments. Whereas in the Nigerian society, not more than 50% of employees are paid cash in hand. And with that, it is difficult to be able to trace the movement of cash around. And also, there are a lot of cash goodwill being given out to members of the public. I think it is high time that that should be stopped or gradually phased out. And it's going to be difficult in the sense that the level of literacy in Nigeria is very, very poor. The amount of people that are not educationally savvy or not able to do either mobile banking or internet banking, it's very, very high. And also the banking industry as well is not very encouraging. If we look at Section 3 of the Act, Section 3, subsection 1 states a transfer to or from a foreign country of funds or securities by a person or body corporate, including a money service business, of a sum exceeding $10,000 or its equivalent shall be reported to the unit, Central Bank of Nigeria, and Securities and Exchange Commission in writing within 1 day from the date of the transaction. A report made under subsection 1 shall indicate the nature and amount of the transfer, the names and addresses of the sender and the receiver of the funds or securities. Transportation of cash or negotiable instrument in excess of $10,000 or its equivalent by individuals in or out of Nigeria shall be declared to the Nigerian Customs Service. The Nigerian Customs Service shall report any declaration made under subsection 3 to the Central Bank and the unit. Subsection 5. Any person who falsely declares or fails to make a declaration to the Nigerian Customs Service under Section 12 of the Foreign Exchange, Monitoring and Miscellaneous Provision Act commits an offense and is liable on conviction to forfeit the undeclared funds or negotiable instrument or to imprisonment for a term of at least 2 years or both. So, let's analyze Section 3 before we move on. So basically, Section 3 of this Act place a duty international funds or securities to and from a foreign country, exceeding $10,000. That is, if I were to uh, bring in funds or securities from a foreign country, I have a duty to report this to the Central Bank of Nigeria in writing, and also to the unit of the EFCC that deals with money laundering. So I'm required, or even the company, if it's a company, they are required to report this within a day. So if that report is made after a day, that is an offense because we've not complied with the provisions of Section 3. Section 3 says if you bring in funds or you take funds out of Nigeria to a foreign country, if you do that within a day, either you are individual or a company, you are to report in writing to the Central Bank of Nigeria and also to the EFCC, that's the unit department that deals with money laundering. It is not clear what is meant by in writing. In writing, does that mean by if I send an email, is that in writing? It will be um, it will be prudent on my part to make inquiries with the Central Bank of Nigeria and also the department within the EFCC that deals with these sort of transactions, to know that, to find out from them, as this section is vague, hopefully maybe it will explain further down the line, but at the moment it is vague in writing. What is in writing? Is it writing, physical writing? Is it email writing? Is it text messages? All this plays, is it a WhatsApp message? Is it message through Facebook or Instagram? We need to understand this. So we need to make contact before we embark on this transaction. We need to make contact with the EFCC and also the Central Bank of Nigeria to find out what means of communication will be acceptable for us to be able to, for us not to be caught by Section 3, so that we can effectively communicate this to them. So it is prudent on our part, businesses, individuals, to be able to liaise, to be able to engage with these departments of government in order to be able to effectively make that communication with them. Section 4 is quite a long section, so we're just going to try and look at Section 4. If we're unable to finish Section 4 today, we might continue from where we stop, because I don't want it to be convoluted so that you don't lose the concept of the sections that we're reading. So Section 4 talked about a financial institution and a designated non-financial business and profession shall identify a customer, whether permanent or occasional, natural or legal person, or any other forms of legal arrangement using identification document as may be prescribed in any relevant regulation. Verify the identity of that customer using reliable, independent source, documents, data, or information. Identify the beneficial owner using relevant information or data obtained from a reliable source, such that the financial institution or the designated non-financial business and profession is satisfied that it knows who the beneficial owner is. And subsection 1D, take reasonable measure to verify that any person purporting to act on behalf of the customer is so authorized, identified, and verified the identity of that person. Subsection 2, financial institutions and designated non-financial businesses and professions shall undertake customer due diligence measures when establishing business relationships, carrying out occasional transaction above the applicable designated threshold prescribed by relevant regulation, including transactions carried out in a single operation or in a several operations that appears to be linked, carrying out occasional transactions that are wired transfer. There is a suspicion of money laundering or terrorist financing regardless of any exemption or threshold, or the financial institution or designated or non-financial business and profession has doubt about the veracity or adequacy of previous obtained customer identification data. Financial institution or designated or non-financial business or profession shall conduct ongoing due diligence on a business relationship, scrutinize transactions undertaken during the course of the relationship to ensure that the transactions are consistent with the institution's knowledge of the customer, their business and risk profile, and where necessary, the source of fund, and ensure that documents, data, or information collated under the customer due diligence process is kept up to date and relevant by undertaking reviews of existing record, particularly for higher risk categories of customers or business relationships. Financial institutions and designated non-financial businesses and professions shall take appropriate measures to manage and mitigate the risk, and where higher risks are identified, apply enhanced measures to manage and mitigate the risk. Where lower risks are identified, take simplified measures to manage and mitigate the risk, provided that simplified customer due diligence measures are not permitted whenever there is suspicion of money laundering or terrorist financing. And subsection 4C, in the case of cross-border correspondent banking and other similar relationships, and in addition to carrying out customer due diligence measure, gather sufficient information about a respondent institution, assess the respondent institution's anti-money laundering and combating the finance of terrorism control, document respective responsibility of each institution in this regard, and obtain management approval before establishing new correspondent relationships. A casual customer shall comply with the provision of subsection 2 for any number or manner of transaction, including wire transfer involving a sum exceeding 1,000 US dollar or its equivalent if the total amount is known at the commencement of the transaction, or as soon as it is known to exceed the sum of 1,000 US dollar and its equivalent. Subsection 6, where a financial institution or designated non-financial business or professional suspects or has reasonable ground to suspect that the amount involved in a transaction is the proceed of a crime or an illegal act, it shall require identification of the customer, notwithstanding that the amount involved in the transaction is less than 1,000 US dollar or is equivalent. Financial institution or designated non-financial business and profession shall put in place appropriate risk management system and procedure to determine whether a customer or the beneficial owner of a customer is a politically exposed person. Subsection 8. In relation to a foreign politically exposed person, a financial institution or designated or non-financial institution shall, in addition to the requirement of subsection 1 and subsection 2, obtain senior management approval before establishing or continuing for existing customer such business relationships. Take reasonable measure to establish the source of wealth and the source of funds of customers and beneficial owners identified as politically exposed person, and conduct enhanced ongoing monitoring on that relationship. Subsection 9. in relation to a domestic politically exposed person or person who has been entrusted with a prominent function by an international organization, the financial institution or designated non-financial institution shall, in addition to the requirement of subsection 1 and subsection 2, adopt the measure under subsection 8 where there is high risk business relationship with such a person. So we are going to analyze this very long section 4 and see what we make of it. So basically what section 4 is talking about is the fact that financial institutions and designated non-financial businesses and professions. If you want to know the meaning of some of these words or names, if you want to know the meaning of financial institutions and also the meaning of designated non-financial businesses and profession, if you scroll down to section 30 of the Act, actually gives you the interpretation and the meaning. For instance, designated non-financial businesses and profession includes but not limited to automotive dealers, business involving the hospitality industry, casino, cleaning and settlement companies, consultants and consulting companies, dealers in jewelry. You have also legal practitioners, you have mortgage brokers. And so there is a host list there. It's actually from A up to T, different designated non-financial businesses and professions that has been identified. So basically what they are required to do is they must conduct due diligence and identify their customers, and also they must make sure that there are trails of the investigations. In my opinion, this is a huge responsibility given where Nigeria is as a society. Uh, in terms of the infrastructures, the network that the businesses, the banks and the businesses, what they are required to do. I'm talking from the point that we have challenges of electricity, we don't have a good internet infrastructures, we don't have a digital bank identification process. Nigeria is still much reliant on paper documentation, which slows the process. If you're talking about carrying out due diligence, this due diligence you have to carry it out digitally. Do you have the infrastructures to be able to carry out this due diligence digitally? And if you're talking about paper trail, does that affect the time frame? These are things that we need to take into consideration as a country and the government most especially in order to make room for Nigeria to grow, in order to be able to accommodate efficiency and speed, in order to effortlessly and deal with inquiries and processes. It also comes down to the different departmental institutions of the Nigerian government, like the department within the EFCC, the central bank. They have to be efficient in being able to communicate with these businesses and also banks. And also the banks and the businesses should have infrastructures in order to be able to liaise with their customer, in order to have a speedy and a seamless process that will create efficiency. As you've listened, we've talked about section 1 to 4 of the Money Laundering Prevention and Prohibition Act 2022. This is just a prelude. This is just an introduction to actually going into the nitty-gritty of this act. We'll be looking at how Nigeria is compliant, or how Nigerian government is compliant to this act. We'll be doing a lot of more research in order to identify those lapses, and hopefully we will get it right this time. I hope you've enjoyed the little brief analysis of this act. Next episode, we are going to continue from section 5 and also look at what those provisions are. Please like the program. Provide your comment, either general comment or specific comment in relation to what we've discussed today. And please subscribe so that you get frequent notification or when we post new episodes on YouTube. Just want you to note one thing. We need to work together as a nation in order to get it right. Take care now and bye-bye.